Good afternoon, everybody, and thank you for joining us today at this webinar. We've got a panel of experts from FTI Consulting and Bristows ready to discuss and assess the severity of a data breach. So my name's Karen Briggs. I'm a Senior Managing Director and Head of the Forensic and Litigation Consulting practice for EMEA at FTI Consulting. My background is in regulation and financial crime, and I'm chairing today's panel session. So as a backdrop to this session, the world has changed exponentially this past year, and we're seeing an increasing volume of cybersecurity breaches taking place. Now more than ever, it's crucial for organisations to ensure they are resilient in the face of this threat. Organisations need to be able to recover quickly and gain visibility of exactly what took place and be prepared for the consequences that might follow. So welcome to all our audience. I can see people still joining, but we'll continue. Our audience today ranges from general counsels to data privacy experts from a whole range of industries. We will be recording this session for future reference. So I'm joined today by Marc, Dorlick and Anna Clark, partners at Bristows, and Patrick MacGloin and Paul Reilly from FTI Consulting. First, I'd like to hand over to Marc to introduce himself before we get into the meat of the panel.
Super, thank you very much, Karen. Good afternoon, everyone. I'm one of the partners in Bristows' data protection and cyber risk practice. I've been working in the field of IT law for perhaps 25 years or so, a bit longer. The sort of work that we do in the area of cyber risk falls into a couple of different categories. We do some advisory work, which is before the event, so before an incident takes place. I hasten to add, not technical advisory work in the sense of questions about how to configure your firewall or your overall security posture. We defer to our good friends at FTI Consulting on those sort of issues, but advisory in the sense of the legal tests for adequate and appropriate security measures. And then we do a lot of work after the event, which divides into three areas broadly. So incident response, that very early stage of getting on top of the incident and, where appropriate and necessary, reporting it to a supervisory authority. There's then a second stage, which tends to be much longer. You don't always get there, of course, which is regulatory investigations. And then a third stage, which is litigation. I tend myself to get involved in the first two of those, and my colleague Anna Cook. I very gladly defer to her when we get to questions about litigation. So as a practice, the Bristows team is involved in all of those areas, and it's very much international work, although we are ourselves a UK law firm, currently operating from about 287 offices around London. Can I say that? Small joke, sorry. In my own case, I first started working on these kind of incidents about 12 or 13 years ago. There wasn't a mandatory legal reporting framework of the sort that we have now. In fact, we didn't even call them cyber incidents, or I don't know anyone who did at that time. So a great deal has changed since I started doing that, although I was just thinking about that, and mysteriously, perhaps one thing has stayed the same. So many of them seem to kick off on a Friday or a Friday afternoon. Anyway, that's by the by. That's me. Thank you, Karen.
Anna, over to you.
Oh, I'm a litigation partner at Bristows, and I work alongside Marc. I'm part of a group of 17 lawyers specialising in IT issues, including data breach.
And
thank you.
And my name's Patrick MacGloin. I'm a partner, senior managing director at FTI in our EMEA cybersecurity practice. My background is quite long and checkered, starting off in UK military and then the UK Foreign Office. I then went into the world of commerce. I was a partner at several big consultancy firms and did a stint as a security advisor for a Middle Eastern government. My background really is specialising in terms of dealing with the threats, if you like, and that means not only reacting but also protecting from certain threat groups. And indeed, recently I was working on a case, a ransomware case, where I first came up against a particular threat back in 2012. Changed their operation styles a little bit in their most recent activities, and perhaps we'll touch on that later. In terms of specialities at FTI, as Marc alluded to, in a similar vein, that Marc alluded to, we help organisations harden and protect, but also, and for the purposes of today, react when there has been some kind of breach. And that's really typically divided into three components. So the primary impact, if you like, is the immediate incident response, getting things back up to speed. From a technical perspective, that means containing any breach and making sure that there's no lasting implications. Secondly, the secondary impacts are in and around regulatory reporting or similar, so performing post-incident reviews and whatnot. And then increasingly, actually, the tertiary impacts, which, because of the complex nature of digital business these days, and we're all digital, it's actually looking at litigation and responsibilities in and around and the pressures that's coming in that direction. Perhaps I might hand over to Paul now.
Perfect. Yeah, thank you, Paddy. Good afternoon. Paul Reilly, a managing director in our cybersecurity practice at FTI. Born out of 12 years in the British military, specialising in intelligence, 8 of those in the Royal Navy, 4 in the Army, before 7 and a bit years ago moving into professional services, where I joined cybersecurity function, firstly at KPMG, then Deloitte. Spent time post-breach in 3 of the largest European breaches that we have to date. And one of those, I will talk around the margins a little bit later, just to add a war story. But focus really on that post-breach, the post-bang and recovery exercises.
Thank you very much, panelists. Thank you, Paul. So we've got some set questions we're going to ask the panelists today, but we'd also like to hear your questions as well. And you'll see a tab on the screen where you can do that. And I can see those questions and I can put those in. And please do feed them in, because we'd like as many questions and we'll try and answer as many as possible. But before we kick off with the panels, we're going to just run a poll. We've got 3 polls throughout this panel, and we're going to run with the first one, if we could do that, please. So our first question is, do you think there is clarity from an EU perspective on the required standards for information security? And this is a soft question, yes, no, yes, you're getting the idea. 30% of people have voted, 35% we'll go for a minute or so. Yeah, I think we've got 70% of people voted. I suggest we close the poll because it looks like it's a slam dunk. The answer is no, there isn't clarity. So let's kick off. So that was 80-20, the answers there. 80 no, 20% yes. So let's kick off with Marc with the first question. Marc, talk us a little bit about what is the required standard when it comes to security in the EU, and is there such a thing?
Thanks, Karen. Well, evidently not, according to the audience. So I've got a job cut out to try and convince you otherwise. Let me try and approach it from a European perspective, because that's the bit I know anything at all about, and then try and break it down into different areas so that you've got data protection and then some types of law, which of course you have security incidents that won't necessarily engage personal data at all, and we've got evolving legal requirements for those in the last few years. So at the heart of it, you've got data protection law, and actually the security principle at the heart of data protection is not new. It's been around for a very long time, and I can see that it's a frustrating thing insofar as it's principles based as opposed to the US approach, which tends to be a rules-based regime where you have quite prescriptive rules. The European approach is principles-based, and so at the heart of it, you've got this, what's now Article 32 in the GDPR, and I'm just going to have recourse, if I may, just for a minute, I think it's worth just reminding ourselves, refreshing ourselves on exactly what it says. So taking into account the state of the art, the costs of implementation, and the nature and the scope and the purposes of processing, as well as the risk of varying likelihood for rights and freedoms of natural persons, the risk to individuals, a controller or a processor, those two types of organisation, shall implement appropriate technical and organisational measures to ensure a level of security appropriate to that risk, including, and then the law goes on to spell out some types of measure, so pseudonymization and encryption. We can get our heads around those, broadly speaking. And then some things which at least illuminate the topic a little bit, I think. The ability to ensure ongoing confidentiality, integrity, availability and resilience of the processing systems and services, the ability to restore availability and access to personal data in a timely manner in the event of an incident, a process for regularly testing, assessing and evaluating the effectiveness of those measures. And in assessing the appropriate level, those parties have to take account of the risks presented in relation to an accidental or unlawful destruction, loss, alteration, and a number of other acts in relation to the data. Of course, not all of these events necessarily engage personal information, and so we have a number of other regimes in Europe from a legal perspective, again, some of which have been around for a very long time. So the Privacy and Electronic Communications Directive has been around since 2003, albeit it applies only to providers of public electronic communication services. And that uses very similar language to talk about appropriate technical and organizational measures to safeguard the security of providers of those services. Much more recently, you've got the Network and Information Security Directive. That is not itself a cyber law, in that, in seeking to provide a legal framework to address threats posed to network and information security systems, it will encompass incidents that may not have a cyber cause at all, for example, flooding or earthquakes, but which may lead to disruption of critical national infrastructure. And then I think where it starts to get a little complicated, what are these legal standards which we talk about when we refer to particular schemes, such as in the UK, you have Cyber Essentials, for example. So a government-backed scheme to try and help organizations of all shapes and sizes, not just small ones, to translate some of these principles into technical controls, and Cyber Essentials sets out a series of 5 principal technical controls. And you then layer on top of that sector-specific requirements. So for example, the NHS has mandated that as of June next year, all NHS organisations need to achieve Cyber Essentials Plus certification, so independent certification of those controls. And you have other sector-specific law as well. The medical device cybersecurity regulations spring to mind. In all of that, at the heart of it, and I haven't even mentioned ISO standards, I'm not going to say anything about those, but at the heart of all that, I would contend that there is actually a broad and flexible set of legal principles, and it's inherently a dynamic set of principles which flexes to context. So it's not an answer to your question like the proverbial meaning of life. It's 42. And the flip side of that is inevitably you get a lot of edge cases. And of course, I suppose as outside counsel, we tend to see a disproportionate number of those edge cases. In other words, where at the heart of it, there is a contextual question about whether in the given circumstances, an organization has applied these principles and these standards in a way that the regulators, or for that matter, the courts, will say meets the required standard under the law. And I think perhaps I'll just wind up there by saying I hope we'll come on to the question of, at that point, what you really want, and what I think there is a lot of confusion about collectively, is to try and narrow down the issues, sometimes using an expert who can give some independent view about what the benchmarks are in a given context. To use a very simple example, the organization is a retailer, a national or regional retailer. The issue in question doesn't necessarily engage payment card data. Are the benchmarks that apply to that organization the same as those that apply to a global tier 1 financial institution that does handle payment card data and other account information? We would say, of course not. And that's the whole point. They're flexible enough to apply to achieve a slightly different outcome for the retailer in my example. And that's where you often find, if you're in a serious process with a supervisory authority like the ICO, that you may have quite some difference of interpretation. And expert witnesses, I hope we'll get a chance to come on to talk about those a bit, can help to narrow down the issues in dispute there. So I hope, Karen, that's my vote for yes. I think we do have some of these legal principles, even if they're imperfect.
Thank you, Marc. Anna, is there anything you'd like to add to that?
Yes, thank you, Karen. The points that Marc has highlighted underline how difficult it is to impose a contractual standard on someone, on a third party or an outsourced service provider or a supplier of some sort, to get them to adhere to a security standard. So there is certainly a misalignment between the regulatory approach and the approach that is likely to be taken by the court in the event of some downstream litigation. I think we'll come on to that in the context of the discussing experts.
Thank you, Anna. Paddy, something to add to that?
Yeah, perhaps to compare and contrast against the legal perspective. I mean, I think there's some really interesting points there. From a practitioner's perspective, though, I think it comes down to the definition of information security, or even that more nebulous term, cyber. To illustrate the challenges in this space, back in 2017, the G20, they commissioned the Financial Stability Board, the FSB, frustrated at different use of language, not least numerous, in fact, too many standards that are out there, to compile what's called the FSB lexicon, the cyber lexicon. Now, this was a global initiative which pulled together lots of different standards and terminology with the idea that we'd have the ring that would bind them all and that we'd all be able to speak the same language. Unfortunately, in this very dynamic world of cyber, the fruits of that labour perhaps has been as divisive as they were to begin with, and by the time it completed, unfortunately, the dynamic world had moved on as well. I think we cannot lose sight of that, and that adds sort of from a practitioner's point especially, with ramifications when it comes to the legalities in and around, a level of expertise that is required to interpret what exactly has happened. When it comes to standards themselves, I mean, I think it's very interesting, Marc's comments, and it is absolutely true that the European approach has been principle-based, but that again can be compared and contrasted with the US approach, which is much more prescriptive in and around the standards that are used. And if we deconstruct, returning to the European sort of perspective, we can deconstruct actually what it looks like here in Europe. There are really, from a practitioner's perspective, 3 key pillars for those minimum standards, or the required standards, sorry. The first one is around GDPR, as mentioned. The second one is around the NIS regulation, so the Network and Information Systems. And then the third pillar is really sector specific. As mentioned earlier, there are some in the healthcare, but by far the area that's been most regulated for some time clearly has been the financial services, and there's a long-standing approach in the financial services about required standards, the minimum requirements that are expected out there. Now, whilst these and those standards, just to illustrate, would include the Bank of England's cyber resilience testing, something called CBEST, which started back in 2013, has expanded not only in the UK and is now moving on to other sectors, particularly in the critical national infrastructure space, but a methodology really that is about cyber stress testing that's also been adopted in Europe under something called TIBER EU 2018, and also elsewhere beyond Europe, in Hong Kong with ICAST, and emerging comparisons in developing countries, Africa and the Middle East, as well as moves perhaps in North America to adopt the approach. And the approach is quite interesting because whilst it's principle based as well, it actually doesn't worry about the controls inside an organization. It worries about whether you are vulnerable to specific threat groups. A hacker doesn't really care whether you've met required standards or not and the certification on your wall. He really wants to get in there. These emerging sector standards are much more focused on actually how the bad guy thinks about things. There are a couple of things that also need to be taken into account, I think, in Europe from a European perspective, and particularly the moves in around digitization, whether that's open banking, PSD2, or various other aligned initiatives coming from EBA, ECB, but also NISA and elsewhere. And a key tenet of that is the move towards digitization, which, let's face it, has, by all accounts, accelerated during COVID, goes hand in hand with cyber security. There's an expectation built into regulations coming out where those required standards and the regulations where they're captured are embedded, that there will be either privacy and or security by design. That said, compliance does not equal security from a practitioner's perspective, nor are you able to have the correct contingencies and protection for eventualities. And it's for some of those reasons that as a practitioner, I very much like working with lawyers so that I have the correct privilege, for reasons perhaps we'll go into later, when investigating such types of incidents. I think I'll pause there, I'll stop there and perhaps hand over to Paul to see if you've got anything to add, Paul.
No, yeah, thank you, Paddy. Only to reaffirm that I think the obsession around standards and achieving that and then stopping and pausing, it's the second law of thermodynamics, which was entropy, which was what I was hammered for, one of the war stories, which is where you don't just stop, you actually decay once you stop moving forward and progressing. And as the threat landscape continuously evolves, this question around, is there a required standard? I think the answer naturally would be the 80-20 split, because we've got to constantly evolve the security requirements and demands on different organizations and sectors based around the risk profile that that sector and industry is seeing, and also those actors who don't care what sector or industry you're in. So I think it's a live and evolving requirement, and we need to be conscious of how it creates fatigue. And I think we've almost got to just be on the front foot always, and that's the difficult thing, to show investment and that return which is needed.
Great, thank you, Paul. Thank you, everyone. Shall we move on to our second poll now, before we launch into the second question, please? So, do you believe the legal and non-legal considerations are aligned when you're leading an investigation? Yes or no? 75 no, 25% yes. Well, that's quite clear then. Right, I'm going to hand over to Paul. What do you, can you elaborate a bit more on the legal versus non-legal, and what might be in scope of sort of typical type forensic investigations in these situations?
Yeah, of course. And I think for this, I'll play upon one key war story that I've got from a few years ago. But At the back end of this, I'm going to naturally hand over to Marc to talk around the legal and the legalese around this implication. But I think the key message that I'd like to talk about is the fog of war. Firstly, to say there is no such thing as a typical forensic investigation. I think everything is absolutely unique in that respect. So the organisation that I worked for post-breach suffered a fine of about £500,000 in the ICO, but then the cost, everyone just assumes that's the cost, but 20 times that was spent on remediating. And part of that is the investigation and actually having the confirmation that the issue has been contained and eradicated. And I think that's where the fog of war really comes in. So when you've got supervisory authorities all over you, as well as governmental oversight as well, I think that adds an additional level of issue when you're trying to A, run the business as usual, B, recover from an incident, and C, inform your stakeholders both internally and externally, and your customers as well if they've been affected. It is a massively complex environment in which to operate. Furthermore, as you're doing that forensic investigation, the typical investigation, the smell of blood for any threat actors creates even more noise and reporting. So the organisation I worked in, we were getting reports of certain cybersecurity professionals saying, we've noticed this vulnerability on your network. It could have been absolutely wrong or incorrect, but we had to investigate absolutely everything to the nth degree, because as soon as one vulnerability is found, more people will come looking to see if there's anything more to add. So that's where it adds that real difference between the legal and non-legal considerations and the alignment of that. And I think the other thing to mention as well is having law enforcement involvement as well adds another dimension of real complexity. And that's where, like Paddy alluded to earlier, engaging with lawyers underprivileged is critical in making sure that everything is clean, it's forensically handled. So if it does go to a court of law, it is admissible. But the one thing I would talk about more is the cognitive biases element as well, to make sure that you have a tightly bound consideration of the forensic investigation. You get to the point where you think you've got to the solution or the answer, and you've contained and eradicated and have all the information you want. But what's to say, and I've seen this before, that the issue hasn't breached out further and you're just reporting on this initial breach and you haven't gone far enough to understand broader implications and what's gone beyond that. So I'm highly aware of those cognitive biases, and I think we need to be really conscious of making sure that we actually do bottom out the full investigation from that initial incident, but also anything else that falls out beyond that. Marc, considerations from you?
Okay, thanks, Paul. I suppose a majority of the audience is, I don't know if they're hoping that we'll disagree, but they are suggesting that the legal and non-legal aspects, as the question puts it, aren't aligned. Obviously, I agree with a lot of what's been said in terms of, in particular, of any significant case, the complexity of and speed often of the number of things that go on, and the other point about cognitive bias. For legal advice, there's two quite simple things happen. They're simple to describe, they're harder to deal with. The first one is that whatever the nature of an incident, early on, it is pretty important from a legal perspective to try to get a handle on a simple factual narrative of what has actually taken place. And perhaps it's worth saying that I think there's also a mindset or a myth about that, in that I'm not suggesting that you'll necessarily uncover the truth, as it were. Our own experiences, there are very many incidents where you never quite get to the bottom of all of the detail of what's happened, certainly not when it comes to attribution in terms of who the bad actors, as they're known, are. But that narrative needs to be able to be, first of all, factual, and it needs to be capable of being shared. I'm speaking specifically with supervisory authorities and so forth, and potentially the police if they get involved. The factual bit is very interesting to us from a legal perspective. I'm sure Anna will say a bit about this, and I should be careful to say present company accepted. we often see reports in draft where we wonder whether they have strayed from what we know and what we don't know, and we're all kind of, perhaps as humans, we're wired to start to form a narrative out of the disparate mass of facts, particularly when under pressure of some sort of externally imposed pressures, whether the need to respond to affected individuals, regulatory authorities, internal management considerations, employees, you name it. But the facts can be surprisingly difficult in our experience to present in a pared back way that doesn't stray into conjecture. I think that leads to the second point, which is behind that. I think it's been alluded to in terms of privilege. There may, of course, be a broader document, for want of a better word, which is taking shape, even if it's not always written down. And I think there is a myth here as well about how far and privilege can actually help us, in that the presumption I think we have is that a lot of this evidence gathering needs to be done on the basis that actually privilege might be much narrower than you think. I'm about to stray into stuff that Anna will talk about, so I won't say more about that. I will say one other thing, which is to go back to those expert witnesses we talked about. Again, I find the terminology very confusing when we talk about breaches and when we talk about experts. We talk about breaches both in the sense of the wall or the firewall has been breached, and breach in the sense of a contravention of the law, and then completely different things, and confusingly so for many people in the fog of war, as Paul calls it. The other one is experts. There's experts in the sense of first responder, those people like our good friends at FTI Consulting who might come in and try and help and prepare that factual narrative. But there's also expert witnesses at a later stage, typically, that you might think about them at the very beginning. When the issue in the frame, if you're caught in a regulatory process, is there a credible difference of opinion between an organisation and the regulator about that standard that we were talking about earlier that applies to the organisation? And that sort of expert is quite a different sort of expert. As an expert witness is there specifically to provide an opinion, and what you're looking for is someone who is independent in the sense that, from a legal perspective, Anna will talk about it, from a practical perspective, you have no real wish to have a captive expert whose credibility will be shot down as soon as they come into play, and whether it's actually cross-examination in the court, that's fairly rare in the context of cyber incidents, or engaged in the process with the ICO. If their opinions can be easily set aside and doubted or undermined, they're useless to you. So it's not necessarily a happy relationship to engage with an expert witness, because you need them to come off the blocks and say, this is what looks to us to fall below what's normal, for want of a better word, at the time of the incident in 2015, when it happened, not now that we're further down the track with all these other parties. And this is the benchmark for what an organisation of your type and size, and given the nature of the issues at play, whether we're talking about payment card information or something else, this is what we would expect is normal based on benchmarks from elsewhere. And these are alternative scenarios that I can give you for what I think you should have been doing or were doing. And that's very helpful to narrow down the issues in these processes. And we look for very specific things from a legal perspective when we engage those two quite different types of activity.
I think it would be great to hear a bit more about legal privilege. A number of, you've all mentioned it in different guises, and Anna, maybe talk a little bit about what is it and when do you get it?
Thank you. With legal privilege in this scenario is likely to be narrower than you would hope, or narrower than you would think. So it doesn't cover fact collection exercises. So to the extent that you need an expert to come in and find out what's happened, because the impact of a data breach it's not transparent to a layperson. That expert is in the position of a first responder, and they will be coming in to survey the facts, but also to use their judgment to establish what has taken place. So there'll be some factual findings as well, which probably won't be privileged either. So in the fog of war, there are all kinds of questions being asked of the experts. The lawyers are involved. There will be a team inside the client organisation who will be tasked with getting to the root of the problem. All of this has to be done in record time. It's important to set up the structures inside the investigation to protect privilege and to maximise the opportunities for claiming privilege. So that might involve appointing a small group of people to interact with the experts and the lawyers. But it might also involve separating the issues and the instructions that you give to the expert, so that the report and the privileged information can be separated from the legal advice and the consideration about some of the legal points. So in general, we would try to get the expert to separate the facts and the factual findings from assumptions and opinions, and also to try to create a structure so that the expert can survey everything that's happened and identify what's there, what's missing, what they would expect to see, what's happened, and record it in a way as they find it, a little bit like you would expect, like, you know, we would taught to record things in a chemistry experiment at school. You know, you want an observational survey, and ideally for it to be set out in a format or a structure that's not hierarchical. As soon as you start to make a list of points, you actually give prominence to some and not to others, and that can distract the expert and everyone involved, because it starts to tell a narrative. So the practice that we've evolved is one where you ask the expert to record their factual findings and their observations in something like an Excel sheet or a data structure which doesn't have a hierarchical component to it. And then if it has to be discussed or incorporated in a report, it's much more neutral. And it's also much easier for the lawyers and anyone else to unpack what's an assumption and what's an opinion. And so as the facts change, and it's unusual to get a good handle on the facts within 72 hours, but as the facts change, it allows the expert to assert their independence and to assert their expertise, because they can change their assumptions and their opinions with a lot of credibility if new facts and new issues come to light.
Thank you, Anna. Paddy, do you want to add to that?
Yeah, I think this is a fascinating area. I think it's a very fascinating question, and I think there's some really important points that are being brought up. I think there are two distinct strands, though, the legal and the non-legal. And I don't necessarily think it's always wise that the twain meet. There's a longitudinal aspect to any breach. And if I might, I'll confine my comments in and around UK. There are specific nuances in operating in other jurisdictions, particularly in North America. But if we just confine sort of experience as a practitioner, certainly in the UK, or at least operating under UK law, it is important to get a view of the timelines, and just actually how, for the audience in particular, who I'm assuming are mostly of a legal or data privacy perspective, to think through actually how you go from that moment of fog of war to the cycle of grief almost, because when it goes bang, there's that very early moment, the instant response is all about fixing it, getting it right, understanding what's happened, containing and getting yourself back up. You'll then hit a moment not long after that where you'll need to potentially notify a regulator. and you'll notify that there'll be an investigation associated with, and that's a slightly different, you're meeting a different end there. You're actually meeting your regulatory obligations as opposed to getting the wheels back on the train. Of course, there is a third component, which is increasingly important, and really where, certainly as providing expert witness capabilities as we do, that independence and legal privilege is really, really important. And that's when it becomes slightly contentious. And of course, in a world where we rely on our infrastructure, IT infrastructure, by service providers that are perhaps not inside our own organisations, where we're reliant on third parties to provide services, where there's an increasing focus on the duties at a C-suite and the governance within an organisation to control privacy, but also cybersecurity, that's when it can get quite interesting on the contentious side. So if I paint that panoply, for clear reasons, there are different ends that need to be met as a practitioner across that timeline. Very early on, we're just trying to fix the problem. As we get towards the middle, if we get to the middle, we're meeting a regulatory end. And then when we get to the end, we are thinking about, actually, is there somebody to blame here? Who's going to pick up the bill ultimately? And as a practitioner, our role is very different across that spectrum, if you like. Clearly, the value of legal privilege as a practitioner is in case we spot something that might be awry, where we need to be careful. So perhaps to sort of bring this to life, I can sort of give you a couple of examples, and probably, these are sort of real life examples of things for some of the audience to consider. When you do the instant response right at the beginning, all of the evidence or all of the fact gathering, which actually I'll come back to in a moment, but everything that you gather in that space, one has to remember, is admissible. That is information that will go and that will be freely available, because at that time you're just trying to get everything sorted out. Of course, and actually I think as inferred by both Anna and Marc, that the Lex Technica is not completely codified. Facts, unfortunately, do change, and there are subjectivity in around actually the data cuts of what you're looking at, and the complexities of how infrastructure and systems are put together. Only having a narrow view sometimes of a broader picture can lead you down a completely wrong track. And of course, that is the danger once you get into operating under instruction. When, as a practitioner, should I be operating under legal privilege, under instruction, probably more at the expert end, where we might be either thinking about aspects of regulatory declaration or potentially even litigation at the end, and where I'm being asked for independent sort of expert input. I'm operating under clear lines of instruction, and those are quite narrowly defined. Now, of course, there are three types of scenario which I've come up against, which present all sorts of problems, and for which I'm eternally grateful to be operating under legal privilege in those circumstances. A first one is where you've identified that actually, yes, a breach has been spotted and notified, but actually that was one of several that perhaps the investigation did not pick up on. The adequacy of any instant response investigation was not broad enough, did not complete properly, or completed prematurely. A second classic is that, yes, the vulnerability that led to a breach of some kind, whether that was within an organization, a third-party provider, or elsewhere, that vulnerability is still there. That begs a raft of questions in and around why it's still there and who has responsibility and indeed the competency to have addressed. And then, of course, the third big one, which is a favorite of mine in the not the nicest sense perhaps, is where the attacker is still there. A breach has happened which was which was under the catalyst of an external actor. It was not an internal sort of issue. And actually the person, bearing in mind just how nefarious and cunning some of these actors are, they will often look for what's called persistence. So they will establish access to an organization. They might sell that access on for ransomware or whatnot, but they will actually retain a level of persistent access, which is different to the attack that you've actually seen. And they will reside within networks for a long period, onward selling or using it for their own ends. There are 3 examples where real life examples where I've been brought in very much from an independent expert witness perspective, heading towards the more contentious, where we've identified significant issues that perhaps were not captured early on. And of course, it is much easier to spot some of these later on, but of course, the cost of addressing them and the potential cost of consequence is so much greater. I'll stop there.
Thank you, Paddy. Shall we? So I'll come back to you, Anna. Let's just do this final poll, just to see if people are agreeing with us around this question. Let's have a look, and then we'll come back. So, in your opinion, of the audience, how important is it for lawyers to have suitably expert practitioner support? We've talked about this a bit. Let's get up to 70% voted, and then let's show the results now. So yes, I think everyone's agreeing that yes, it's very important and fairly important. Fortunately, nobody said it's not important or slightly important. So Anna, you were going to speak a bit after Paddy there.
Yeah, sorry, thank you. Really to say that once you move into a more expert phase, once you start to contemplate litigation and the risk of litigation, then the scope for legal privilege becomes much broader. And there are slightly different rules which apply to an expert at that stage. It's governed by the civil procedure rules. The expert confirms that they are behaving independently and they're subject to criticism by the court for a failure to be independent. So it's a very tricky role for an expert to step into. But I think that it's important that although you can assert privilege at various stages of the case, always when the factual investigation, first response and facts come out, they are always vulnerable to being disclosed to the other side. They're very rarely protected by legal privilege.
Thank you, Anna. So very important and very tricky. So shall we move on to our last question? And I've got a few other questions coming through, which I'll put to the panelists as well. But let's face into our last question, please, which is, how do supervisory authorities and courts approach the question of a severity of a data breach? So we've touched upon this a bit in the last question, but Marc, perhaps you could kick us off on how does that get approached?
Let me keep it as brief as I can if we've got other questions coming. Perhaps just highlight a couple of things that are going on in the legislation and the guidance that comes from supervisory authorities. An obvious question that get asked once you get, by organisations, once you're anyway into a serious investigation is how much are we up for? I'm alluding to the question of a fine from a data protection authority. There's an inherent conflict on the face of the statute. You have fines up to a maximum of 4% of worldwide annual turnover for contravention of Article 5, which is the general principle that applies to controllers about security. There's a fine of up to 2% of worldwide annual turnover for that lengthy other half of the standard that I was referring to at the beginning when we spoke, which is Article 32, which sets out in detail the requirement, that principle for and the requirement for appropriate technical and organizational measures. So straight away, you're in an uncomfortable place in having to say that there's no real obvious basis on the face of the statute for that difference. You can tease out some important points to make about it. One article applies only to controllers, Article 32, the 2% one applies to controllers and processors. It seems to be that you'd be setting up an unequal penalty regime if you applied Article 5 with that higher 4%, you could say that one of them is only just a general principle, that's Article 5. The real meat on the bone, as it were, is Article 32, which has a more detailed and specific requirements. There doesn't seem to be any consensus at the moment across the EU, and insofar as these incidents engage data protection at all, amongst the data protection authorities about that. There are certainly instances where in Germany, for example, a regional authority has been minded to look at this through the lens of Article 32, that's 2%. In the UK, the ICO seems to be going in the opposite direction. So that's quite important, perhaps, just to grasp a pretty simple point when it comes to the basic question of arithmetic and how might we calculate what they're in the frame for. And I'll mention just one other point. There seems to be a unpublished draft policy that the ICO has on top of something which is published, its regulatory action policy, which emerged last year, and its legal status remains a bit uncertain. So even in terms of the guidance from, in the UK, the supervisory authority itself as to how it will approach the question, you have what we call some public law considerations, meaning an organisation should be entitled to a degree of legal certainty in a regime as important as a fining regime. In other words, to understand the level of penalty they face. That is not at the moment legally clear. What can you take away from all of that? And then I'll definitely stop. A couple of things, perhaps. We certainly, unless our instructions or otherwise, will be seeking to suggest that there are a lot of things to do in the language of a penalty notice that are important, particularly if you have downstream litigation threatened in the court, I mean, where you might have the prospects increasingly of so-called class actions. The ICO doesn't have a remit in relation to negligence, as that term is often broadly used. It has a remit in relation to a narrow form of negligence, the alleged failure to comply with GDPR principles, but not the broad common law idea of negligence generally. It is important in our view, to some extent important at any rate, to be able to try and get in some language to the effect that the organisation is not making any admission of liability in what's set out in the notice that accompanies the fine. And then there's occasionally what you get is top parity statements, as we call them, the worst security environment we've ever seen. That was one I've had the dubious pleasure of being involved in with the ICO. You obviously want to get rid of those statements. There's very little basis for the ICO to be able to hang on to those, and I'm pleased to say we have managed to do that. But so there's a lot going on in trying to negotiate at a late stage the language that goes with the assessment from regulators.
Thank you, Mark. We've got a few questions coming in, and I'm conscious that we're getting to the bottom of the hour and soon to wrap up. But I think we've probably got a chance to answer one, and I will throw this out there. It's probably more of a legal answer. So somebody has asked, what does without undue delay mean in the context of notification of a breach under Article 33? That's a nice soft question for one of you.
I'm looking forward to the answer.
Oh, if I had the guidance to hand, I think Anna's leaving this one to me. Doesn't it say without undue delay and in any event within 72 hours?
72 hours. 72 hours is the statement actually in GDPR, but actually the interpretation of that in context of when you actually find it, I think I very much look forward to the answer to this.
Yes, there'll be some guidance about this, which I don't have in front of me.
Yes, let me throw in another question then as we concentrate on that one. Somebody else has asked, if you're, as a company director, what can you do to minimise the risk of any personal liability? I mean, it'll have to be a short answer, but some thoughts?
I might give a couple of thoughts, if that's all right, which looking at the insurance market at the moment, D&O, Director and Officer Insurance in this space, is increasing significantly. and is something that many DNOs are undertaking specifically around cyber. That is a consideration.
I mean, I think some of the other considerations are about making sure that the directors are genuinely accountable and that they've genuinely got a listening ear to what's going on inside the organisation. I think some of the areas where I felt a bit squeamish have been around the company's approach to innovation. So if there are parts of the business that do their own private projects because they're creative and they're innovative, how do you make sure, how do you bring a structure into play which supports compliance whilst maintaining the ability to innovate?
Great, thank you, Anna. Thanks very much. Now, I'm conscious that we can't answer all the questions, and we're at the bottom of the hour, so I'm going to wrap up and say thank you very much to all of our panelists for a lively and interesting discussion. We could have carried on for much longer, I've no doubt. Thank you also to the audience. We have done a recording, as I mentioned at the beginning, and we will be sending that around along with a follow-up and some feedback. And I know a couple of you have asked me on the questions, because people have had to be called away before the end, that they can catch up on it. So yes, and thank you very much to everyone. Have a great day.